Hello friends, so today I'm going to discuss section 82 of CRPC. After getting the knowledge exactly verified from the greatest lawyer of Punjab, I'm making this video as well as in the support of the arguments which are presented in this video, guys, that is supported by different various high courts as well as Supreme Court of India. So those authorities would also be presented in this video and they would be linked down below in the description box, right? So in this video we are going to discuss section 82 and the common mistake which is usually done by the lawyers as well as students also. The question of law which arose in this particular section has been discussed in various authorities, but a very prominent authority which has been given by Delhi High Court, I would discuss that, in which the counsel from petitioner was Mr. Kapil Sibal, Senior Advocate of Supreme Court, right? So the common mistake usually arises that is in the interpretation of subsection 4 of this particular section, and that is very important to know for any aware citizen first of all, and then any law student. Law students do a lot of misinterpretation of this subsection 4, so I would make that clear. What is that mistake and how to sort it out, how to interpret this section properly, I would tell you and tell you about that also. And this video is very utmost important for the judicial aspirants also, because this question or this legal issue can be asked to you in the preliminary examination as well as they can ask you in the interview also. So for the judicial aspirants as well as the law students and lawyers, this video is very important. So let's start with the reading of Bare Act first of all, that what it says. By one I would explain you the subsection, and then we would discuss in detail about subsection 4, because there was not any other video on this particular topic regarding the detail of subsection 4, and I would also make you clear what is the difference between proclaimed person and proclaimed offender, right? So let's start with subsection 1. Please open your Bare Acts and start to read with me. Proclamation for person absconding. Subsection 1 says, if any court has a reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by it has absconded or is concealing himself, so that such warrant cannot be executed, right? Yeah, we were on subsection 1. Sorry, somebody came in, so I had so the video got interrupted. Yeah. So basically it says that if any person, it talks about the principle of intention. If the person is absconding or concealing, there are two important factors: absconding or concealing. There is a word written or, not and, right? If he's absconding or concealing, then and in order to not to get the warrant executed, right, that thing is important. Then after then the court, अगर हिंदी में बोलूँ तो abscond कर रहा है या conceal कर रहा है, जज को लगता है on the discretion of court, after considering this principle, on the discretion of court, the court can publish a written proclamation requiring him to appear at specified time, place, not less than 30 days from the date of publishing such proclamation. Then the court, at its own motion, in its own discretion, they can issue a proclamation जिसके अंदर 30 days की dead limit, time limit will be mentioned. So that was all for subsection 1. Then subsection 2 talks about proclamation, the procedure of proclamation, that how it should be published. Subclause 1, clause 1, subclause A says that it shall be read publicly in some conspicuous place. What is the conspicuous place? A place on which the process server can attract attention of other people, right? Yeah, so it should be read publicly. B says the proclamation shall be affixed on some conspicuous part of the house, homestead, or the town or village. C says it should be affixed, a copy shall be affixed to some conspicuous part of courthouse के ऊपर उसकी copy चिपका देंगे. Clause 2 says the court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily. They are talking about the publication to be made on the daily newspaper which is circulating in that place. Now subsection 3, a statement in writing by the court issuing the proclamation to the effect that proclamation was duly published on specified day in the manner specified in clause 1 of subsection 2 shall be conclusive evidence, right? They are saying that if the proclamation has been made and the report has been received by the court, a statement in writing by the court issuing the proclamation, and it is duly fulfilling the ingredients of subsection 2, then it shall be deemed as the conclusive evidence. Very easy to know, no hard and fast rule, very sorted principle. Now comes the very important point, the most important point of this video, subsection 4. It talks about where a proclamation published under subsection 1 in respect of a person accused of so and so offences. It is talking about various offences like 302, 304, 302 punishment of murder, 304 punishment of culpable homicide, and so on, of IPC. And such person fails to appear at specified time and place required by the proclamation, then the court may, after making inquiry as it thinks fit, pronounce him as proclaimed offender. It is saying that if the person is accused under so and so sections which are mentioned in the subsection 4, only then he would be deemed as proclaimed offender. Now here arises a common mistake which is usually done by the students as well as the lawyers also. The question which arose in the case of Sanjay Bhandari versus State and NCT of Delhi. This is the judgment copy. In this, the legal query which arose was, what if the person is accused under the section which are not mentioned in subsection 4? What would be the circumstance then? A very important question. There are specific sections of IPC which are mentioned, and they say if the person is accused under that, then he would be deemed as a proclaimed offender by the court after in getting the sanction of 1, 2 and 3, right? What would happen in those circumstances when IPC sections are some other sections are there and not these which are specifically mentioned over here? Then in this authority the question was solved. In the paragraph 7 of this same authority, I have linked down below. In this subsection 1, they talked about the question that arises of consideration is as to, please read para number 7, as to whether a person who is not accused of any of the offences mentioned in section 82 subsection 4 can be declared as proclaimed offender. वो कह रहा है कि अगर किसी और सेक्शन में वो है accused तो क्या होगा? Now please refer to section paragraph 23 of the same authority. The basic reasoning of the learned judge to hold that all the persons in capacity to whom a declaration has been published under section 82(1) CRPC would be deemed to be proclaimed offender is that any other interpretation would render the provisions of 174A redundant. तो लोअर कोर्ट के जज ने क्या डीम कर लिया था कि सबसेक्शन 1 ऑफ 82 में कुछ भी हो तो द ऑफेंडर विल बी डीम्ड एज प्रोक्लेम्ड ऑफेंडर, अक्यूज विल बी डीम्ड एज प्रोक्लेम्ड ऑफेंडर. इसके अलावा कोई और इंटरप्रिटेशन की गई तो वो 174A ऑफ IPC को रिडंडेंट मान लिया जाएगा, बना देगी. तो इसमें जस्टिस कहते हैं, इन माई व्यू द लर्नर जज हैज़ नॉट नोटिस्ड that provisions of 174 IPC and 174A operate in different circumstances. इसमें उन्होंने 174 और 174A IPC को भी मद्देनज़र रखते हुए उन्होंने अपना व्यू दिया है. Now you have to read paragraph 25, 26 and 27 in order to know what 174 and 174A talks about. I won't discuss that in this video because that is gonna make the video too long, right? So we will just come to our point. 174 and 174A is very important for all the law students, lawyers and judges to read, right? So this is it. Rest of the concept, rest of your concept would be completed by that. And under paragraph 31, most important paragraph of this authority section, paragraph 31, it talks that I am of the view that a person who is accused of offences other than ones enumerated in section 82 subsection 4 and in capacity to whom a proclamation has been published under section 82(1) would be deemed as proclaimed person and not deemed as a proclaimed offender. वो कह रहे हैं कि अगर सबसेक्शन 4 के अलावा किसी सेक्शन में वो अक्यूज्ड है तो उसको मान लिया जाएगा प्रोक्लेम्ड पर्सन एंड नॉट प्रोक्लेम्ड ऑफेंडर. So this is the basic difference between proclaimed person and proclaimed offender. Proclaimed offender is that person who is accused under the specific sections which are mentioned in the subsection 4. So the person who is not liable for these sections which are specifically mentioned in this subsection 4, he will be deemed as proclaimed person. And the second difference in proclaimed person and proclaimed offender is that of the liability. Under subsection 174A, proclaimed person will be liable for 3 years imprisonment, and under the same section, proclaimed offender will be liable for 7 years of imprisonment. Because why is it so? Why this distinguish has been made? Difference has been created because in order to give relaxation to those offenders who are offenders in these sections apart from the subsection 4. And even if you look at the sections which are mentioned, like 395 punishment of dacoity, so these are basically the grave offenses. So the legislation has deemed them as grave in order, so that's why a grave punishment also has been, a grievous punishment has also been specified in IPC for them. So this was the basic difference between proclaimed person and proclaimed offender. And the case is Sanjay Bhandari versus State and City of Delhi. That was all for today, my dear friends. If any doubt arises to you still, there's a great question usually asked by the students, again in the form of misinterpretation done by them. The question is that what would happen if the person is and accused of 138 Negotiable Instruments Act. They say that the person again becomes a proclaimed offender even if it has not been specifically mentioned in subsection 4 of 82. Then how do they become proclaimed offender? See, in the answer to that particular question is that it is expressly provided in the Negotiable Instrument Act that they can be also declared as proclaimed offender, because it is expressly provided in that Negotiable Instrument Act. Apart, if the CRPC is only covering IPC, not all of the acts, right? So other acts can provide that the person can be declared as PO or not. So this is the solution of the query. That's why in 138 Negotiable Instrument Act, the person is deemed as proclaimed offender because it is specifically provided in that act. Thank you.